guest host is Clay Whitaker. How are you doing, Clay?
I'm fine, Jim. Can you elevate me now? I've been a guest host now several times. Can I be co-host?
All right, I'll call you a co-host, but just for today. Ladies and gentlemen, today I've really had some thoughts on my mind, and it was spurred by David Tulis. Yesterday, I was listening to the station, and David was talking about being in court on Monday for a motion call in circuit court and listening to Basil Marceau's case against Sadi Daisy and being able to interview the parties to the case and listen to the arguments and watch how the court ruled. And that's a essential element of our government.
I think that's right, Jim. It's always a concern with the courts is that we want to try to keep, I don't know if the word pollution is the right idea, but to try to make sure that the potential veneermen, the issues that are available for those people who are going to make decisions in the case, not to be influenced by folks that are not ordinarily supposed to have additional knowledge that they wouldn't have by their own senses.
Right, but that's the other side of the balancing that we have to do, because essential element to all of us as citizens of this country are to be able to have a court system where we can go and watch the court system, participate in the court system, have access to it for redress if you need it, or at least to be heard if someone's accusing you of something and challenge and cross-examine, but it's an open system. And that was something that David was able to do as part of the press. Was he was able to go up and sit in court and interview the parties and have access to the court records and know what was going on. And we try cases in Hamilton County and, of course, all through the state every day. We have motion hearings. We have evidentiary issues arise where citizens can walk in and just watch. In fact, Mothers Against Drunk Driving used that opportunity to put a lot of pressure on the criminal courts by sitting in there and watching how the courts were handling drunk drivers and impressing upon the courts that citizenry wanted harsher sentences and more stern treatment to try to stop that. So they've used it, even the opportunity to be in courts, for a political purpose. But there is a balancing. That's what you just mentioned, Clay, is, and that came up in the news as well with this Benjamin Brewer, who's charged as a result of the accident that happened out near Ooltewah, where he was driving a truck out of control effectively. And at least there's some issue whether or not he was on narcotics at the time, and caused several deaths and maimed a lot of people as a result of driving over the road as a professional driver.
So if we were going to sort of announce what we're talking about today, it would be something related to whether or not the access to trials should be public, whether they have that, I guess, subsumes the arguments related to the First Amendment, and then what the relationship with counsel is, what attorneys have in regards to that particular thing. Is that a good way to put it? Or
well, that, or I would have probably said it more simply, is the publicity and confidentiality of court proceedings. For Mr. Brewer's standpoint, publicity has been a bad thing. And as a result of the knowledge in this community, the court has determined that we're going to choose our jurors from Davidson County. And, that's something that, because I don't really do any criminal work, and I know you do a great deal of it, Clay. That is an issue that comes up really in the criminal arena. And what are the issues that the court looks at when we have to say that the local veneer, the jury pool of Hamilton County, is so stained or tainted because of publicity that's been in the local press, on the various medias, the internet and the like. It has so tainted the potential of getting an impartial jury that we've got to go outside of the county. How does that happen?
Well, I'm going to continue the theme of keeping it simple, Jim. And that is that we've got to basically make sure that everybody receives a fair trial. That is the constitutional standard. That's what the court looks at. So you have to balance, and it is always the need of the balance of the local community to be able to express themselves, to participate, as we would say, with the jury of peers in handling any criminal issues that arise from our community. That is to apply the law, to review the facts, and to sort of mete out that justice here in our community, as opposed to the defendant's right, which usually is paramount to the first thing I just mentioned, and that is to have a fair trial. Got to make sure that the person who's charged has the right to be able to receive fairness in regards to the veneer pool. So if the pool's been tainted, corrupted, have information they would not have had as a result of that, that's something all attorneys, even when you're beginning your cases, inquire about, and the court inquires about what the jury might know about the particular case that we have.
Well, but it seems to me that flies in the face, and and I talked about this coming over here today, that, you know, jurors are seen and are intended by the community to be our heroes. They know the local standard that we expect people to comport themselves by. We know what we expect as justice in our local community. And so when we go to court and watch a proceeding, or we're keeping up with a court proceeding or a trial that's going on, and the jurors there, that jury is we, the community's hero, that is going to hear the facts, hear the law, and is going to mete out justice for us and do what we can't do because we're not in the jury box. And we get that taken away when jurors from Davidson County are the ones that are meting out justice for us.
Well, that's certainly a concern, but I think that the natural law, which is always what is captured by our Constitution. You know, the Constitution doesn't guarantee any rights. The Constitution is a reflection of the natural law, and certainly is a document that tries to mimic and reflect the natural law. That is, that we recognize that a person needs to have jury members that have their common sense, but that are not bringing their own opinions about a case in that they've gained outside of the presentation of evidence. So on the one hand, yes, the community needs to be able to participate, have an open forum, and have justice presented in an open fashion. You know, we always battle against the so-called star chamber, where trials are done in secret and you don't know what really happens. But at the same time, you've got to make sure that a person that's deciding whether or not you're guilty beyond a reasonable doubt actually hasn't learned anything outside the case that they're using to make a decision in the case, which would not be fair.
So basically, the rights of the individual, the defendant, trump the rights of the community or the justice system in that regard.
I think so, and I think that's the way that we believe the balancing should be done in the criminal setting, at least. It's not quite the same in the civil cases, but in the criminal setting, you know, the idea always is, and we know this from our popular culture and from our civics lessons, and that is that the person that's charged is presumed innocent. And so in terms of the presumption, the cloak of innocence, you want to have a jury that is also not corrupted. That is, a jury that's not polluted by the information they may have gathered outside of the jury or outside of the courtroom where the evidence is presented, because that's really what the government has to do, is to present evidence and to try their case with the proper standards, and not have a jury. And this is one of the things the court handles. The court asks these questions, the attorneys ask the question, and we want to make sure that juries, what information they may have gathered is not something that's going to affect them at trial.
Right. And I think a reverse for Hamilton County occurred when the Vanderbilt football players were charged with rape and improper conduct towards a young woman student up there. The Hamilton County jurors were chosen to try that case up in Davidson County. Yeah,
that's a good point, Jim, that we've had the same effect here from other counties. And, you know, today's age, there's so much information. It is the information age. And as a result of the places that you can find out information, for instance, I had a case that I tried in the Northern District of Georgia in the United States District Court there in front of Judge Murphy, for those folks who might be listening from the Georgia community. And in that case, there were several what I would call amateur media persons. They had their own web places or websites. They were not hired by any particular news entity, and they came and they reported on the conduct of the trial and the things that were happening in their community. That's a great example of how communities are able to learn from information from people who were there. They may not be able to take off work, but these folks that were putting out the information about the testimony at trial did two things. One, it was a concern that the people who might have been on the jury might have learned information about what was presented from other witnesses, but at the same time, it provided information to people in the community about what was being said at trial. So it's difficult these days, and judges have a great deal to consider when they're trying to move a case to determine whether or not the person that's on trial can receive a fair one. So you mentioned Vanderbilt, great example. I think that was a proper decision because of all the publicity that had been received from those Vanderbilt University football players.
Yeah, agreed. And you know, so the freedom of the press, the First Amendment rights that we enjoy, have basically increased the cost, at least from the criminal standpoint, for the administration of justice, because now with so many media and so many opportunities to receive information, good or bad, about any possible pending criminal matter that's out there, there's more opportunity to prevent a jurors from being able to render an impartial opinion without having some knowledge or being affected some way by something they've read or heard, either on the internet or in the paper. Listeners, if you have a question about the issues with respect to publicity and the right of the community to know and understand what's going on in the courts, or the opportunity of the press to report, you can call us here online. The number is 423-800-8949, and we'll be happy to discuss with you the issues. Now, from the standpoint of the press is regulated by the courts as well. Now, you hear of gag orders and the like on parties, but there are rules in place already that address when the press can act in a courtroom, what they can record, where they can interview, and the like with respect to criminal proceedings.
Well, that's true, Jim. Why would, let's discuss that for a second. So why would the courts have to enter those kinds of restrictions on the basic constitutional right? You know, we get the idea that our constitutional rights are without restriction. In some regards they are, but many times you have to have some qualifications to that. Media is one of them. What would be the reasons the court might have to do that?
Well, you've got you got to control the proceedings. You can't have the proceedings disrupted. So if you had a lot of media in a courtroom and they were either flashing cameras or trying to move around with video equipment and the like, it could be disruptive to a juror being able to focus on the testimony of a very material witness. So you've got to control what's happening in that vacuum we call a courtroom as facts are being presented.
Seems to me, you know, the most obvious example of that is the O.J. Simpson trial, because we don't have that sort of thing. I don't recall that sort of, as it was described, as a media circus that's occurred here in our area. But if I recall, that each day of the trial was broadcast, people wanted to look at it, and as a result, the jury had to be sequestered. You had to protect the ability for the jury to not be exposed, even accidentally, to some sort of media that might have exposed them to the testimony that it had previously.
Right. And our Supreme Court has a Rule 30 that is put down with respect to the conduct of press, and that's been adopted by our local rules here. I know I was looking through the rule book to see how many times media are addressed or publicity is addressed in our rules. And Rule 11, which pertains to criminal courts, specifically provides that media or their agents who record or broadcast in a courtroom shall understand and comply with Tennessee Supreme Court Rule 30, which governs access to the public judicial proceeding, which prohibits the recording or broadcasting of certain participants in a proceeding and certain proceedings and conferences, limits the number of participants that can be involved, the sensitivity and obtrusiveness of certain media devices, and that's what we were just talking about, how it can actually be obtrusive and affect the ability of the jury or the court to listen to evidence. It also may allow them to limit the number of media that can attend, so that they have to pool their resources and have one person perhaps or a few people take the information and then provide it to the press pool itself. And it further provides for here in Hamilton County that at no time may media record or broadcast from the third floor of the city county courts building. Now, Clay, what's on the third floor of the city county courts building?
Well, the city county courts building has the criminal court. So when those people that are particularly charged with offenses and it could be either misdemeanors or it can be felony charges, if you're seeking a jury trial, they're going to be held on the criminal courts in the criminal courts building on the third floor.
Right. Third floor is where divisions 1, 2, and 3 of criminal courts are held.
That's correct.
All right. So on that floor, you're prohibited from the media is prohibited from recording or broadcasting on that floor of our courthouse unless they're in compliance with Rule 30 and or on an invitation. They can also go to the office of the district attorney for an interview. So there's pretty much a limitation from a criminal standpoint by our local rules on what the media can do here in Hamilton County. And I will tell the listeners that being familiar with the local rules across the state, as well as in North Georgia, the uniform rules, there are limitations on media across our metro area with respect to access and control, not a limitation on what they can understand and hear, but how they do it, so it's not disruptive to the system.
So we would be doubly barred, Jim. We could not have the remote broadcast of Legal Bytes there at the courthouse. And I ask for the many callers who want to call in and talk about legal issues on this show, 800-8949. Please give us a call. We'll talk with any of those issues you want to about your legal issues that may have come to mind. We're attorneys from the law firm of McCoon, Williams, Ashley, and Stanley, 756-6400. Just give us a call. Thanks.
Right. Now, the limitation on the media is not where it stops. Attorneys and parties are also limited by the rules, as you and I both know. So that there's a limitation on, say you've got an attorney and he's handling your case, and say you're suing Corporation X, and you really want to take steps to harm them for what they've done, and not just financially in the courtroom, but you want to hurt their reputation. And so you want your attorney to go out there in the press and put out basically banner advertising about the case. You want him to call press conferences and issue news releases about everything that's going on and provide them with details that aren't in your complaint and not in the court proceedings. That can't happen, can it?
No, it can't, Jim. I mean, we have here locally, there's the media outlet. One of our TV providers has Just Call Calvin, not to plug another media provider. But in that set of circumstances, I've had to ask people, well, why can't you do just what he does? Why can't you expose these things? And of course, our rules require attorneys to be ethical. And many people don't understand the number of restrictions that the ethics rules require for attorneys. One of them has to do with trial publicity. There are a number of local rules. Also, not only are they the Tennessee Bar of Professional Responsibility rules, there are several different code sections for those, but you also have local rules that do the same thing and restrict us. So we can't, and we have got to maintain a professional conduct. And as part of that, we can be sanctioned. We can have sanctions apply to us and probably to our clients, depending upon what is actually said, since we are their representatives.
Right. In fact, the rule provides, from our ethics standpoint, that a lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial, that means outside of court, statement that the lawyer knows or reasonably should know will be disseminated by means of public communication, i.e. the media, and will have the substantial likelihood of materially prejudicing and adjudicated proceeding in the matter. So if you have the intent of prejudicing the potential jury pool in Hamilton County, or affecting witnesses who may be coming in because of the pressure of the community having seen what you've said, those kind of things, that's just can't be done. Now, a lawyer can acknowledge that an investigation may be ongoing. A lawyer can advise the scheduling or the next steps in litigation, so that if I know one of the local web-based newspapers always talks about major lawsuits that are filed, and that information, of course, is a public record. And once they do that, if anyone contacts the attorney who filed that suit about, well, what's the next steps, he can discuss when there's another hearing. He can advise when a trial may be set and the like. but he can't discuss the merits, pros and cons of the case.
So the safe harbor for us attorneys, when we're talking about these particular issues that are before the court, is basically what a public record might be, or
Exactly.
in the general sense, what maybe legal issues you might discuss in the very general sense, not specifically about your case.
Right. The limitation or maybe the exclusion that might be if there's a need to advise because of potential danger. Then the lawyer can discuss those matters, but he's got to basically reasonably consider that everything that is discussed is either appropriately factually based upon the public record or necessary for the public to know because of public need. Now, if you get into a criminal proceeding, it's a little broader. He can advise more about addresses and information where things happened or may have occurred with respect to a proceeding. But again, there's still the same limitation that we are not to take steps to try to affect either the jury or to affect the proceeding through whether witnesses, witness testimony, and the like. And it's much like the same. It's almost like we're trying to make an end run if you do these things around what the old term is jury tampering. Where you try to actually discuss directly with the juror what's going on in the case and affect their consideration of the facts. Well, here you're trying to do it indirectly. A lawyer would be by trying to put out publicity that might affect the jury pool either before the jury pool the jury is selected, or afterwards while the case is proceeding, if the jurors may happen to watch television, happen to access the internet and the like, which I know the courts usually advise the jurors not to do that, but it's oftentimes hard to stop that from occurring.
Well, Jim, how do we explain these attorneys that get on national television and start talking about the merits of their case? I've seen a number, particularly this last summer, there were a number of cases, and I believe most of them involved some sort of claim of racial discrimination. There are a number of attorneys that were involved in those cases, and they began to discuss the facts of the case. I've always wondered how they avoided, if they could, any sort of censure by their professional responsibility overseers.
And I agree. I have problems with oftentimes what's said. I know myself, when I've been contacted by the press, I usually will have to advise that I just can't make any comment at that time because I'm often concerned about how far I can say anything without raising the ire of the court or of the ethics rules and crossing the line. So I usually have no comment whatsoever. But I think what happens in those cases is either they are basing what they say on what's either already been filed and we just don't have access to that information, or they are riding hard on their First Amendment right of freedom of speech, because it's a little further than I would go. Well, I see we finished the first half hour, Clay. Listeners, I hope you'll join us as we return here after the news with more of Legal Bytes, and we'll talk to you then.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
3, 2, 1.
Chattanooga Radio, AM 1240 and 92.7 FM's news now.
A possible bomb attack was thwarted in Hickson. Police say they found a man with a homemade explosive device outside businesses in Hickson late Tuesday night. The police say Joshua Redden has been arrested. He's 34 years old, charged with possession of a prohibited weapon, public intoxication, possession of drug paraphernalia, and possession of a controlled substance. The police performed a controlled detonation and destroyed the device. A modern-day Bonnie and Clyde, a couple has been arrested after the police say they robbed multiple businesses across the area. Peyton Cleveland and Bailey Roddy have both been arrested. The police say Cleveland was the muscle man while Roddy was a getaway driver. Miss Roddy was already facing an assault charge from May the 3rd. U.S. Senator Lamar Alexander from Tennessee has secured $37 million for construction on the Chickamauga Lock. The U.S. Army Corps of Engineers will continue construction this year. Alexander says everyone who receives shipped goods will benefit. Russell Stroud, Nooga Radio News, now.
In-depth traffic, news, and information. Mornings on Nooga Radio, AM 1240 and 92.7 FM.
Scattered showers and storms will slowly slide off to the east through your afternoon. Still quite wet, high 70 to 72. Tonight, turning cooler. Any spotty showers diminishing, lows 52 to 55. For Thursday, partly sunny, drier, pleasant, high 73 to 75, and more sunshine for Friday. Keep your lawn and garden looking great all summer long with Glass Farm Nursery. From flats, hanging baskets to trees and shrubs, they have all the color you need. Open daily, closed Sundays. Glass Farm, Highway 11, 4 miles south of Trenton. And I'm Swarsheen 12 Chief Meteorologist Patrick Orr. On Nooga Radio, AM 1240 and 92.7 FM.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune Williams and Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and legal emphasis, but we share one common goal: providing the highest quality legal services to our clients through the combination of our talents, experience, and expertise. In each case, we strive to tailor those services to meet each client's specific circumstances. Business law, business organization, civil litigation, commercial litigation, conservatorship and guardian law, bankruptcy law, just to name a few. With over 188 years of combined experience, McCune Williams Ashley PLLC is here to help you and your business succeed. MWALawfirm.com. That's MWALawfirm.com. Call 423-756-6400. That's 423-756-6400.
Picture that curl of steam rising from your fresh-made pizza. And in a flash, let it take you aloft, teasing all your senses. I'm talking about Jet's Pizza. If you eat out at Jet's in Hickson or take home your steaming deep dish square pizza, you'll love Jet's. They use only the best ingredients in a family recipe. Also try the cheesy bread, wings, chicken, or bread with bacon, antipasta or Greek salad. Jet's Pizza and Buy Low near the S-Curves. Open till 10 p.m. Sunday through Thursday and 11 p.m. Friday and Saturday. You can order online or have it delivered. jetspizza.com. That's jetspizza.com. Or call them now. They'll have it ready when you get there. 757-1616. That's 757-1616.
Jet's Pizza, the best pizza in town. 3600 Hickson Pike.
Life is short. Eat better pizza.
Let's get Jets.
Need a tiller to get things going for the spring? Smooth up your porch, maybe your deck? Come on by and get a pressure washer at Action Rental. Family in town, need some tables and chairs for an event? Come on by and see us. Action Rental. This is Dan at Action Rental on Lee Highway. Come by and see me. Action Rentals.
Nooga Radio, AM 1240 and 92.7 FM knows your opinion is important. So call 800-8949. Agree or disagree? Call 423-800-8949. 800-8949. Nooga Radio, AM 1240, 92.7 FM, and 95.3 HD4. News, talk, sports. Nooga Radio. The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
Well, welcome back to Legal Bytes. This is Jim McCoon, your host, with Clay Whitaker, our co-host. And we've been talking today, listeners, and during the first half hour about publicity of court proceedings and the right of the community to have involvement in our judiciary and in how we mete out justice in our local communities. And when the media and the information that's in the community can affect that right. And for example, as we talked about the Benjamin Brewer case that recently was announced, that we're going to be picking our juror for that truck driver on the interstate that caused so much mayhem. We're going to have a jury picked in Davidson County. We had the jurors for the Vanderbilt rape case. We had those jurors come from Hamilton County. So there are often times when this is occurring, and it's because of the fact that media in this information age, as you put it, Clay, are now providing so much information that it's hard to get an impartial jury in the community that is so affected by the outcome of the litigation.
Well, I was going to ask you, Jim, so in the civil arena, we've got the same concerns in the civil arena, but they're addressed differently. Can you tell us a little bit about that?
Well, sure. I mean, from the standpoint of business litigation specifically, we get into situations where we are dealing with trade secrets. We can be dealing with financial data, pricing, cost of goods sold, information that would be of a competitive advantage to other businesses to know how their competitor, who happens to be in litigation, is actually costing and pricing and marketing perhaps their product or even designing it. So those issues are extremely sensitive in business, and to keep a business from having to choose whether to either disclose their information and be open up to competitors or just not file litigation because they need to keep it confidential and private. There are methods within the civil system or in the court system, because I think they're also available on the criminal side, where we can get what are called either protective orders or confidentiality orders. And those are done on a regular basis, especially in business litigation. And in those situations, what we do is often we'll reach agreement, because a lot of times we'll have business to business litigation ongoing, and both sides want to have information protected. Or even if not, the attorney representing the litigant who's not involved with their financial information being disclosed understand and reasonably can appreciate that these issues have to be addressed. So what we do is we do an order that the court will have to review and approve, where information will either be noted as confidential and therefore it won't be disclosed to anyone other than the parties and their counsel, and if necessary to an expert that may be brought in, an accountant, a forensic specialist of some kind, maybe a marketing analysis kind of guy. They will come in, but they'll be governed by the protective order as well before that information is disclosed to them, and it won't go any further. And if and when we get to a point where a deposition or trial testimony is occurring, we note for the court the confidential nature under the protective order that we're about to go into, and that information is noted in the transcript, and steps may have to be taken in court depending upon how sensitive it is as far as excusing people or limiting who can hear the testimony. But that's addressed. From the standpoint of filing documents, we also address it under the same protective order. So if we're filing documents that necessarily have to include design information or perhaps drafting information on how a patent was obtained or how a certain methodology for manufacturing was conceived, or just our pricing information in general, then that could be filed under seal. And if it's filed under seal, it's not accessible to the general public. When they go to review the court file, they'll be able to review everything else, but the matters under seal will stay under seal, subject to a further order of the court.
So basically, Jim, those things are protected by either federal or state law, and that particular information might be guarded, or as you said, there might be orders that are either protective orders or confidentiality orders that control the release or the viewing of those documents. But the whole proceeding is not in any way affected by that. It's still an open proceeding for those who want to come see it.
Sure, it's still an open proceeding, and anyone, including your competitors, can sit there and watch it happen. Now, on the personal injury side of civil litigation, we get into a lot of personal information being disclosed either in tax returns, whether there's a lost wage claim or the like, or in medical records because of HIPAA and the personal identifiable information that would be out there. And so likewise in personal injury litigation, there'll be steps to protect those personal identifiers with respect to medical treatment, financial information, tax returns. So that happens there as well, because you certainly don't want your Social Security number, how much you make, where you're banking, all that information disclosed to the general public simply because you need redress through our court systems.
Well, Jim, we're here discussing these issues related to the openness of our court system. This is Legal Bytes. We're a legal show discussing the legal issues that are relevant to the Chattanooga community. It's 800-8949. Give us a call. We'd be pleased to discuss either these issues that we're talking about or other ones that may come to mind. But on that note, Jim, I wanted to ask you, I have many times, we're both trial attorneys, many times that witnesses ask, why have I been required to leave the courtroom? Isn't this an open proceeding? Can't I watch what's going on? Why can't I participate in this process just like anyone else in the gallery?
Oh, we're talking about the rule of sequestration.
Yeah, that's it, Jim.
All right. The rule of sequestration is in place because you don't want someone hearing how other people are testifying so that they can then modify or mold their testimony to be consistent or maybe be inconsistent depending upon who they're testifying for. So for that reason, we've got a rule that basically excuses the witnesses from the courtroom until they're called to testify and prohibits them from discussing among themselves with the parties or with any witness who's already testified what occurred in the courtroom. And that way we're trying to keep their testimony pristine, if you would, from being affected by what's already occurred. And it's a wonderful rule. I use it often. I know you do as well, to try to make sure that we get the truth as best we can in the courtroom. And a lot of times, for example, you may have an individual come in and it's a situation of a factual dispute, and you have a witness testify one way and you call another witness and they have seen it a totally different way. And they through their testimony, in fact, impeach or discredit the testimony of the other. Well, if they had already heard how the other one had testified, they might have changed that testimony, and you don't want that to occur. So that's where the rule comes in. And I know the public, especially these witnesses who are so involved and have taken time out of their day to come down and testify, are really frustrated by the imposition of the rule. But if they understood, and hopefully if they're listening now, they can understand how important that rule is to gathering evidence in the courtroom for the trier of fact, whether it's the judge or the jury, and making sure we get impartial evidence and direct evidence that's not tainted.
Well, and unless you're going to be recalled as a witness, and sometimes that happens, but most of the time courts ask attorneys that are involved in the litigation after a witness testifies whether or not that witness is subject to recall, and that is whether they may have to come back and testify a second time or to clarify their testimony. If they don't, many times they're allowed to stay in the courtroom. Isn't that right?
Yes. And, basically what the judge asks you is this witness excused. And if you've excused them so they're no longer going to be called, they can stay. Now, there are a couple of times when witnesses who haven't been called can be in the courtroom before they're called. I know, for example, experts are often allowed because they're not considered factual witnesses and are rendering a professional opinion and are actually hired and paid to do their professional work, are allowed to sit in the courtroom from the very first witness, a lot of times to either aid counsel in gathering information that's necessary from a technical standpoint for that witness's expert's opinion, and it hasn't been elicited or it needs to be clarified, and he'll be there to advise counsel what he needs to do. He's there to hear. I know several years ago, I tried a case involving a major will dispute, and we were trying to establish that the decedent who had signed the will had Alzheimer's at the time and advanced Alzheimer's, but there'd never been a diagnosis at the time. So we'd brought in a psychologist who was forensically recreating the timeline of the development of her disease. And because of that, he had already interviewed a number of witnesses before trial, but he was sitting and listening to testimony so that he could, one, testify that based upon the testimony that he had heard, were any of his opinions affected, because he had given his opinions before trial. And so a lot of times you need that just to be able to buttress your expert testimony. So they are allowed to stay in court, but a general lay witness needs to be sequestered.
Well, I've got one for you, Jim. I had a trial while I was involved in representing a railroad company, and the court allowed a lay witness to listen to the testimony of the train engineer because he was a lay witness expert. And so he was also an engineer. And so the court had given him the authority to sit there and listen to the testimony so he might critique the engineer's testimony. And so it is one of those unusual sets of circumstances, but generally the rule is just what we were talking about. That depends on the set of facts, but the court can give leeway and does frequently.
Yeah, you're pointing out that the judges have discretion to control their courtroom and control the testimony and control the order of testimony and who, in fact, will be affected by the rule of sequestration.
I think it's just attorneys, Jim, as many people like to say, picking and choosing as they like. So,
now, Clay, from the standpoint of criminal proceedings, are there confidential matters that come up?
Oh, there are many times there are a number of issues, that can be brought up. And I think you've mentioned the classification of cases that you might be able to say that in, and those might be business crimes, white collar crimes, where trade secrets and sensitive, valuable information might be released. And that happens many times. So I think I read one recently about where a narcotics manufacturer, a pharmaceutical company, had a very large judgment issued against them by the United States government, who had prosecuted them for a number of different crimes related to the False Claims Act. And as a result of that, ended up having a huge judgment. But in the course of that case, there were trade secrets and issues that would be considered very confidential and secretive, and they would have been protected, of course, as you'd already mentioned, that the court has the authority to do that.
Right. And something that's just more usual and not as sexy is embezzlement. There are
True.
a lot of businesses, and I've been involved because of work we do through credit unions and their insurers, where officers of credit unions have embezzled funds in certain very distinct instances. And we've been involved in the investigation and prosecution. And a lot of times what you're getting into there is not only the financial records of the institution, but the financial records of members of the institution. And as a result, Tennessee has the Financial Records Privacy Act, where as a matter of law, we have determined in this state that financial information and financial records are private and confidential and should be protected as such. And so not only do we have to take steps to comply with the Financial Records Privacy Act, but we also have to take steps in court and in proceedings related to a trial to make sure that that information isn't disclosed.
Well, Jim, I was going to ask you, we've been talking a little bit about, and this is sort of jumping around, but we talked in the first half about having jurors that were not tainted. And so that some ways you have to look in other areas geographically might be one way to protect a particular defendant's rights, or if you are in a civil case, you might protect everyone's rights by having the case changed to a different forum. What skills or what tools do attorneys have in being able to determine whether or not a jury has had some tainting? So in the veneer pool, I know that we use here locally certain jury information sheets or questionnaires that we would use. Are there other tools that attorneys have that would allow them to locate or determine whether or not that particular jury might be tainted in that area, or to locate other veneermen that wouldn't have that problem?
Well, I mean, if you're talking about actually in the trial selection process or jury selection process, during the voir dire, you can ask the jurors with respect to information they may have relative to the issues that are about to be tried. And you can talk to them if they have any information, where it came from, find out how much they read, where they read, and the like. And you can use that information to exclude them as a matter of cause if they formed opinions with respect to what's going on. So you can get there, but at that point in time, it's really too late to try to get another forum. You're stuck with the veneer that's going to be provided out of this court's community. And so all you're doing at that point in time is trying to make sure is out of the pool of that community, the voir dire that you do establishes that there's some prejudice or some formed opinions that would cause them not to be impartial and cause them not to be able to serve on your jury panel.
So I know here locally, the courts have allowed and continue to allow in certain cases interrogatories that you might develop, submit to the court, and have the court either approve or to in some way edit those interrogatories to determine what sort of prejudices and bias that the jury might have that might also reflect the effects of media coverage. And that's also available in civil cases. And there are also experts that sort of focus on the ability to determine what kind of jury pools that we have and whether or not they've been affected.
Oh, absolutely. I think most attorneys nowadays have used experts not only in trying to do simulated or mock summary trials before they get to court to find out how the evidence is going to be heard by a potential jury and how their backgrounds may affect how they will rule on your case. But I also think that experts are now in the courtroom with the attorneys, helping them select the jury and picking out who will best serve based upon the questions that are asked, who would provide them with the best opportunity to rule the way they want that panel to rule.
Well, we've got a curious set of circumstances coming up here, and it may be not that unusual, but with the Benjamin Brewer case, you've already mentioned that they're looking to have perhaps have that jury pool come from another city. And we've also got the case of Jonathan E. Walker, the Woodmore bus crash case. That might be the same. Both of those cases not only have criminal cases involved, but they've also got civil cases involved. You expect at one, for example, one of those cases to have that is the criminal cases, to have a different veneerment pool come from different cities geographically, but not to have the civil cases tried anywhere but here.
Right. I agree with that. And why do you think that's the case?
Well, I think that's the curious thing about our law, but it's the different standard that's required. It's what we sort of discussed in the first half, is the protection of the defendant provided by the Constitution and by all of our criminal statutes and rules that basically try to determine when you're dealing with the beyond a reasonable doubt standard to make sure that the veneer pool is untainted and that it's a fair trial and that the difficult standard of conviction is upheld. And
it's better than 10 guilty men walk free than one innocent man be found guilty.
That is simply said, Jim.
Yep. We are truly looking after the rights of the individual and our justice system, and this is a credit to our government. Our justice system will bend to make sure that those individual rights are protected.
And so the civil cases, not to diminish them, not to say that those aren't important, because obviously the rights that are being adjudicated in those civil cases are very important, particularly involving the unfortunate and untimely deaths of children. Those particular cases, I know we try cases like those, and that in these particular instances, it's not to diminish their importance, but it is to say that we believe that even with regards to the possibility of the tainting of the jury pool, that there are steps that the court can take to make sure that a fair trial is received.
True. And frankly, an individual or a company have a better chance of getting a fair trial, in my opinion, in a large city than in a small city. I'll never forget, I was trying a case over in Gainesville, Georgia, and this is many years ago, and Gainesville even smaller then. And I think every juror on the panel had gone to church with or used the law firm on the other side. And the judge would not excuse them for cause. And he said, if I started excusing them because they knew people in this town, he said, we wouldn't have a jury at all. I mean, and that's what happens in your smaller communities, is everyone knows everybody. And so you just try to do the best you can. And that's what we're all trying to do day to day, listeners, is we're trying to do the best we can with our legal issues, whether they're individual or in business. And that's why we're here to try to help you on Legal Bytes. We're here every Wednesday from 11 to 12, addressing issues that we think are cogent and perhaps informative for the issues you're addressing. And please listen to us next Wednesday at 11 o'clock.
The Tennessee Valley's news, talk, and sports leader. Nooga Radio, AM 1240 and 92.7 FM.
McCune, Williams, and Ashley PLLC offers a full array of legal services to meet the needs of businesses and individuals. Our attorneys represent diverse backgrounds, interests, and